Hello and welcome. We're talking today about copyright termination. My name is Aaron Moss. With me is Dan Stone. We are both lawyers at Greenberg Lusker in Los Angeles, although we should say that the views that we're going to express today represent our own and not necessarily the views of our law firm. You're here because you hopefully want to learn about copyright termination. We want to do things a little bit differently than some of the other programs you may have seen on this issue. We are going to stay away largely from the mechanics, the nuts and bolts of how copyright termination is affected, and instead focus a little bit more on the practical issues surrounding copyright termination, and especially some of the pitfalls and traps that may present themselves when you're dealing with these issues. Dan, would you like to start us off?
Yeah, and just further to that point, I think we're thinking of this presentation as a little more of an issue spotter than the mechanics of how to go through a copyright termination. This is obviously going to be helpful to litigators who have clients who are artists or authors or people who represent companies that deal with them. Also to transactional lawyers who are representing artists and authors or negotiating against them. But I think maybe one of the underserved communities with respect to copyright termination are corporate lawyers who are dealing with mergers or acquisitions or other transactional dealings involving companies that own content and copyright. Obviously, any copyright that has a longer shelf life, you run into termination, which begins in most instances 35 years after the grant at issue is executed. Also in some limited circumstances, this could come up in a software context. Obviously, software is subject to copyright as well. Usually, software doesn't have a 35-year shelf life, but in some circumstances it could. So we're intending this to sort of inform people to look out for general issues, in those type of contexts and where these issues come up. And I guess the first point that you wanted to get to, Aaron, is that the global point that a copyright termination arises under the United States copyright law and only affects United States rights.
Right, and I think that's important to remember because we are obviously living in a global entertainment community, and most of the time it's going to be important to exploit worldwide. And what we see is that more often than not, termination, even if it is effective, results in a renegotiation with the original copyright owner, because that way the same entity can continue to hold on to both the U.S. and foreign rights. If somebody were to terminate, and just for purposes of example, and maybe I'll go back to this throughout the presentation, if you have an individual who has created a cartoon character, and let's say that character was created back in the 1940s or 50s, has over the years became very popular. And now the creator of the character is deceased, his heirs, perhaps there are many of them, decide that they're going to try to recapture the copyright that their father assigned many years ago. We know from termination basics that the statute, which is section 304 C and D and section 203A of the Copyright Act, allow you after a certain period of time, depending upon certain factors, to recapture those rights. And they allow you to do that even if the assignment that was made originally states that it's in perpetuity. So notwithstanding the fact that you've assigned away your copyright, you have the opportunity to recapture it. So now we have a situation where these heirs of the cartoon character creator are trying to decide what they do and what their strategy is going to be. So the first thing in terms of this U.S. foreign distinction is that if they are able to successfully recapture copyright in that character, and they're able to exploit that character in the United States, the original assignee and any licensees that claim through it will still be able to exploit the character in foreign countries, which means that there could be the possibility of conflicting rights and even confusion among the audience as to who's actually putting out the material.
And I think, the second big point, once you're within the domestic realm, is that works made for hire under the Copyright Act are exempt from termination. And so generally speaking, a work made for hire, at least for copyrights that are governed by the 1976 Act, are instances where an author was hired to create something by a company and basically did so as an employee and under the supervision of the company. So not every author, so to speak, or a colloquial author has a termination right. And therefore, one of the first things that you need to look at when there's a potential for termination is this a work made for hire? And if it is, the termination right isn't there. And obviously there can be questions as to whether something is a work made for hire or not. That comes up pretty frequently in the context of a termination or litigation involving termination.
Right, and just to go back to the character examples, so there have been many cases litigated over this precise issue. Two of the most notable are the Siegel case involving Superman and the Kirby case involving Captain America. And in each of those cases, the court ultimately determined that the creator of those characters did so primarily as a work made for hire, and therefore the rights were not terminable. The issue really has to do with whether or not the creator did the character before entering into any sort of relationship with the publisher of the book. And if he did, then any transfer of those rights is going to be by assignment, not work for hire. If, on the other hand, that character didn't exist at the time that the relationship began, courts have been quite liberal, especially for pre-1978 works, in finding that there has been a work for hire relationship. So when we talk about termination, we're going to assume, if we're talking about a successful termination, that there has been an assignment as opposed to a work for hire relationship. But an interesting issue is that, and it's very important when you're trying to value a property and when you're trying to determine what rights are going to be recaptured, is how much was actually created pursuant to this assignment and how much was actually created pursuant to a work for hire. So I'll give you an example. In the case of Superman, you had certain material that was created before there was any relationship with the predecessor of DC Comics. The court found that that material was owned by the creators, could be recaptured. However, almost all of the significant copyrightable elements of Superman were added after Siegel and Schuster entered into their relationship with National Periodical. And so in that circumstance, those additional aspects, those copyrightable aspects, cannot be part of what is recaptured even if a termination is successful. So if you have a situation where most of what makes the character valuable was added later, that is going to make the termination less valuable for a couple reasons. First of all, you don't get to recapture those additions, but even more importantly, you may not be able to exploit the character at all without them, at least not in any way that the public would believe that the character is being exploited.
I think the only point to further that issue is that it also can cut both ways, right? In that, right, there can be additional aspects of the character or features that everyone knows, okay, this is the character we're talking about, but then it's possible also that the original grantee wouldn't have sufficient material to make use of the character either.
Right, and so that's why we end up again with situations so often where there's a renegotiation between the original creator and the original assignee. If the assignee can't exploit its character without infringing rights in the underlying material that was assigned, but at the same time, the creator can't exploit all the derivative material without permission of the assignee, it creates a blocking situation where each side needs the other to really move forward at all.
Right. So a lot of times, I guess what we're trying to say in summary is this sort of work for hire issue can lead to the baby being cut in half, and both sides need one another to put the baby back together and make use of it and make money off of the property. Moving on, right, we're in the United States. Let's assume now that we're not in a situation where the copyright is a work made for hire. The question is then, when you terminate, what are the rights that are actually being terminated and what are recaptured? So one crucial point about what isn't terminated when you're able to terminate and recapture is that pre-existing derivative works prior to the termination are not recaptured. Now, probably one of the classic examples of a pre-existing derivative work is a motion picture. We'll go back to the example of the character that we were talking about before. If there was a movie that was made based on that character, but it's prior to the termination, the studio that made the movie can continue to exploit and distribute that movie that was made. That doesn't apply to remake rights, and I'm sure there are also some other rights that you can think of that are excluded.
Right, and it is important to remember because I've had situations where clients have come in and they've said, I never assigned away my publication rights. So when you don't assign something, you don't need to recapture it. You have those rights. But I did assign away my television rights. And at that point, a TV series had been created based upon her father's idea, and several hundred episodes of this series had already been produced and aired. She was under the assumption that by terminating the copyright and reacquiring the TV rights to that copyright, she would somehow become the owner of those several hundred episodes of the TV show. And that's not the case. Because those episodes were created under the terms of the grant while it was in effect, those are considered to be works derivative of the original idea that was granted, original story idea, copyright that was granted, and therefore not subject to termination. So what she would be able to do upon terminating those rights or those grants would be to do her own TV shows based upon the original copyrighted work, but that would not affect either the original assignee's ability to continue to exploit the TV episodes, and it certainly would not have allowed her to exploit them herself. So again, it's important to remember, if you do terminate, what exactly are you going to recover and how valuable is it? It's another example, again, of why so many times the original assignee ends up striking a deal with the person who's able to recapture the rights, because that company may be the only one with the interest or wherewithal to create additional episodes, for example, of the TV show, and it's a natural fit.
I think the big takeaway of this point with the derivative works is that, except for really the example that jumps out at me is a book, except for a book, in most instances, you're not going to be able to recapture the original content that was produced, right? What you think of as the valuable property that was produced. So you write a script as an original script, you're not going to be able to recapture the movie that was produced or the TV series that was produced, or even if we would go into something along the lines of a commercial or some short content, you're going to be able to get back the right to the screenplay that was originally written or the teleplay that was originally written, and that usually manifests itself in a remake right. So really, termination in those type of instances is most applicable when there's a property that has a long shelf life, an enduring recognition, and there's an opportunity to remake it, either as a remake of a television series or a remake of a movie. Another example of a derivative work context that people sometimes don't think about are samples of songs, right? So if if there was a musical composition, a recording. Let's leave aside the fact that most recordings are works made for hire. If you were able to have a termination right in a recording, the recording and the composition that's embodied in the recording are then sampled in, let's say, a rap song, a hip hop song, right? That hip hop song and the sample are pre-termination, they're derivative works, and they stay with the original grantee, right? So once again, you're not getting that content back. You would be able to potentially get back the content as it's used in the future.
Right. So I guess, worst case scenario for somebody who's looking to recapture rights or trying to decide whether it makes sense to recapture rights is, going back to the character example, the character was created before the relationship between the creator and the publisher was entered, so it is an assignment that's terminable, but most of the valuable plots and sub-characters and maybe even additional attributes of the main character were created after it became a work for hire. You have a situation where it has a very big foreign following. You have a situation where there's already been a lot of exploitation in a lot of different media that continues to be popular, and where the ability to exploit it if you terminate is not going to be very great. So in that situation, you would be able to stop the original assignee from creating new versions, but you really would not be able to do a whole lot yourself. So, when you're looking at these things, you have to decide, am I looking to terminate so I can make a deal? Am I looking to terminate so I can stop somebody else from using a property that I don't want them to use in a certain way? Or am I looking to be able to exploit it myself, to be able to assign it to another party? If you're trying to do the latter, you're trying to exploit it yourself or assign it, you really need to determine ahead of time what exactly are you going to get and how valuable it is, because as we all know, these termination notices are often contested by the owners of the rights, and you may spend many, many years, in the case of Superman, 10 years litigating, many millions of dollars to do so in legal fees, and at the end of the day, even if you prevail, you really won't have the right to exploit it yourself. Now, if you're looking to use the leverage you'll gain by blocking the original assignee, that's a different story, because even though that original assignee can continue to exploit all of the derivative works that have already been created, it can't create new derivative works. And if there's an interest in doing so, if it's an evergreen property where that is valuable, then the very fact that you can prevent the original assignee from creating new works gives you a lot of leverage in renegotiating a deal. But again, we're talking about getting compensation, maybe having some participation in the development of that new property, but not being able to wholesale take it back. So in that sense, this idea of recapture, while theoretically a possibility, is very seldom actually used.
Well, and so I want to draw a distinction, because a lot of what you're talking about is literary material, right? And I think there's a big distinction in termination of literary material, where there's a lot of development under the work for hire rubric, and music, where there is a greater ability to recapture the entirety of a work.
Right. I think that's important. I mean, we can talk about the difference between a screenplay that's turned into a movie, or a book that is then turned into a TV show, versus the music situation. Maybe you want to talk a little bit about the music situation.
And so certainly in the music context, there are a couple of key distinctions. First is obviously a lot of songwriters have songs that they wrote that are theirs, that are not works made for hire, that are terminable. And when you effectuate termination, you get the song back. You get the rights to the song back. Obviously, it's difficult to distribute or administer the rights in a song, even domestically, by yourself. But then you would have the opportunity to reassign and negotiate a new publishing deal for the song that is yours. And there's, unlike literary materials where they tend to develop over time or under the auspices of a studio or a publishing house, a song in most instances is self-contained before you secure copyright. So you're able to really make use of that in its entirety. Also, in rare instances, if somebody owns a master recording, it's the same thing. You would be able to basically recapture the master recording to the extent you assigned it, and then be able to administer and distribute and assign the master recording. I think there's also a distinction in terms of the cost aspect of copyright termination as well. I think the history has been that for literary properties, the literary properties where the termination right is worth pursuing are so valuable that the studios and content owners and distributors really fight very aggressively to keep those rights, and they make termination litigation very expensive. That's happened in some instances in music as well, but because there is the ability in music to recapture, in some instances, the whole of the property, and because there are so many individual works in the music context that are being terminated, it is possible to have a less substantial or less contested termination case, even in litigation. I think Aaron and I have encountered situations which would be implausible in the context of literary material, where a music company doesn't even contest a notice of termination.
Right.
So that is a real big distinction between literary and music.
Right, that's a good point. One other thing that we should mention when we're talking about how, practically speaking, you're able to determine whether there's value in terminating, is whether or not the work that was created and assigned is a work of joint authorship. Oftentimes you will have collaborations where two or more people get together and create a work. So an example going back to Superman is Siegel and Schuster. One was the author, one was the illustrator of the comic. Each one of those, when they together intended to create that joint work, each had an undivided half interest in the copyright. When both of the owners assign their rights, then the assignee, the studio or the publishing company, has 100% of those rights. If there's a termination notice that's served on behalf of only one of the joint owners, and the other joint owner decides not to pursue termination, you could be left with a situation where the assignee, the publisher or the studio, continues to have its 1/2 interest, notwithstanding what could even be a successful termination by the other joint author. So in that situation, the leverage we were talking about earlier, the right to block, doesn't exist. The publisher can continue to exploit. Now there is an important caveat. As joint owners, essentially the studio or the publisher standing in the shoes of one co-author and the heirs of the other co-author on the other side, they then have a duty to account to each other for any profits that were earned from the exploitation of the work. Now, it gets even more complex because the accounting for profits is not profits for the entire work. It's only those profits that are attributable to the work that is being recaptured under the termination. So if, for example, in a case like Superman, the vast majority of the key copyrightable elements that people know and associate with Superman are not terminable because they were written in a work for hire situation, and there's just a few elements that were assigned, a court would then have to determine what percentage is used to determine how much of the share of profits the co-owner is entitled to. And it can end up being a very small percentage, although if it's a key franchise, that could still be worth a lot of money.
Just one point there, because I think there was something baked in there that was assumed. Under copyright law, a co-owner has the ability to assign and exploit as if he is the sole author and owner of the work, and then comes the duty to account, right?
Right. So long as it's if there's going to be an exclusive license or assignment, then there needs to be both, which generally is what happens at the beginning of these relationships. You have both of them assign all their rights in the work, so the studio or the publisher has the complete package, and then it's a question of who is doing what with it. Separate and apart, though, if you have two joint owners, each one can on his or her own enter into non-exclusive licenses and subject only to a duty to account to the other. So again, it's the point is just that these termination rights or what is actually recaptured tend to get sliced and diced pretty thin. We've seen now U.S. foreign, we've seen the issue of derivatives, we've seen add-ons to the work, and you have yet another slicing if there is a co-owner situation.
And so from here we were sort of going to get into some issues to consider from different perspectives in the context of copyright termination. The first is things to watch out for if you're representing the author or the artist who's looking to terminate. And I guess the first big category under that are agreements to the contrary. Generally speaking, the copyright termination statutes are structured and have provisions that say you can't agree to effectively waive your termination right. And maybe you want to get into some of the specifics of that.
Yeah, I mean, so the classic example would be if there were an agreement that says, I hereby assign you my right to create a motion picture based upon my screenplay, and I also agree that I will never take advantage of the copyright termination statute that would allow me to recapture these rights. That on its face would be an agreement to the contrary. It would be an agreement not to terminate, not enforceable. So notwithstanding that provision in the contract, the author or his heirs can terminate the grant and recapture the copyright. Now that is kind of the most garden variety situation, and as you might expect, nobody's putting those clauses into agreements anymore. Instead, there are much more nuanced and subtle issues that some of which courts have yet to even consider regarding whether or not something is an agreement to the contrary.
And I think it's worth, since we're talking about agreements to the contrary, to understand the concept. It's important to understand how it developed in the context of renewals under the 1909 Act. Basically, under the prior Copyright Act, there was an opportunity for an author to renew the copyright, which effectively was supposed to serve as a recapture. But what happened is the courts allowed for agreements that at the beginning of the relationship with the assignee would say, you're assigning me all of your renewal rights from now until the end of time, and effectively the author was never able to recapture the rights in the copyright. So the termination right and this principle barring agreements to the contrary was really designed to remedy that.
Yeah, the criticism would be that it's somewhat paternalistic, trying to protect authors from themselves, but I think it's more a recognition that at the time that a property was created, there is a relative inequality in bargaining position between the author and the assignee, and the idea is that you want to allow, if the property becomes successful, there to be the ability for the author or his heirs to share in the fruits of that labor. There are nevertheless a whole host of things that you will see in agreements that have the effect, if they were upheld, of preventing the exercise of termination rights. So one that we see very often are clauses in contracts that say that everything that is being done from here on out is on a work for hire basis, but everything that has already been created is retroactively going to be deemed a work for hire. And the idea there is to try to prevent the author from exercising termination rights, even if the work was created outside of the relationship between the two parties. By and large, courts have found that any sort of attempt to classify a work as a work made for hire retroactively is not valid. Instead, you're going to look to what are the actual circumstances of the work's creation as opposed to what the parties later said about it. And if in fact the work was not created for hire originally, then the termination can move forward, and any statement that says that there's a retroactive work for hire would be essentially an agreement to the contrary. It would be invalid.
Yeah, and I think without getting too deep into this, because we could do a whole nother presentation just on this topic, but there are different standards for what constitutes a work made for hire under the 1909 Act, where it developed more by common law, and then under the 1976 Act, where again, Congress more narrowly defined what a work made for hire is, and it's more difficult in a way to prove that something is a work made for hire when it was created after 1978.
Right. Yeah, the way that this would normally arise in these more recent works, these post-1978 works, is you'll have, for example, a writer will do a spec script, will do a screenplay on his own without any involvement with a studio. That's clearly a situation where that's not a work for hire. But then we'll enter into an assignment agreement with the studio. We'll assign rights in that first draft screenplay to the studio. We'll also be hired to do rewrites of the screenplay, and we'll be deemed to be doing that on a work for hire basis for all of those rewrites. And that's perfectly valid under the 1976 Act. You can have a commissioned work that's part of a motion picture, but then it creates a situation where we have that distinction. The first draft was not a work for hire. The second draft that's actually turned into the movie is a work for hire. Let's say that 35 years after the grant, there's a termination. What exactly is terminated? Well, nothing in the second draft that wasn't in the first draft can be recaptured. The author does not have any right to that because it was created on a work for hire basis. The only thing that the author can recapture is the original draft. Now, that's fine if all of the key characters, plots, and themes, etc., are contained in that first draft and the second is just polish. But often we have first drafts that look nothing like second drafts, and if all the value is in that second draft that looks nothing like the first draft, then the termination right is not all that valuable.
And one thing that we were just talking about the other day are instances where there's another author who's brought in to rewrite the script, right? So you could have a second or third draft of a quote-unquote original screenplay that's written by someone completely different and that bears almost no resemblance to the original draft. And then, down the line, those are going to present thorny issues with respect to termination. There's obviously going to be a termination right in the original draft, but once again, I would anticipate that gets back into the splitting the baby type of scenario with everybody incentivized to find some sort of happy medium where there's a deal. So, the original studio, in all likelihood, is going to be able to exploit the idea.
So again, on the author or grantor side, things to watch out for. We talked about agreements not to terminate. We've talked about these retroactive work for hire agreements. Another type of clause that we see in these contracts are contractual right of first refusal. So this is a situation where the assignee says, I know I can't get you not to terminate. That would be an agreement to the contrary. But if you do go ahead and terminate this assignment that you're making to me now, and then you decide to go off and exploit your newly recaptured right with someone else, you need to give me a right of first refusal on the same terms to exploit it. So if that agreement is valid, that would mean that at the very last minute, the assignee could say, okay, I like the deal that you're setting up with Studio A, and I'm now going to be able to do the same deal and, in essence, keep my rights. Now, obviously, there will be additional compensation there paid to the original creator or his heirs, but it does have the effect, as a practical matter, of limiting the amount of interest that that other studio would even pay in looking at that property, knowing that it might be snatched away by the original owner. So that is not a situation that, to my knowledge, has been tested in court, whether or not that would be, in effect, an agreement to the contrary, these contractual right of first refusals. We have baked into the statute, we have statutory right of first refusals, essentially, which, not really right of first refusals, but right of first negotiations, at least, that say that for the period of time after a termination notice is served, but before it takes effect, the only one that can make a new deal with the terminating party is the original assignee. That is something that is valid and appropriate, but what we don't yet know, we don't have definite guidance from the courts, is whether or not these contractual right of first refusals are valid.
So now we're going to approach this from a different perspective, from the perspective of a party that is an assignee, and the termination would actually terminate or recapture the rights that they currently own. So there's the prospect of losing your rights. And what often comes up in this situation is the assignee is thinking of, is there a way to claim that this work is a work made for hire, or is it in fact a work made for hire?
Yeah, and that's really, if you're representing a publisher, or studio, or any other rights holder, a record label, a music publisher, that's really the first thing you're gonna think about. You're gonna say, is there some way that I can attack this on the grounds that it's not terminable in the first place, that it's a work made for hire? And we have two different schemes, as we touched upon earlier, depending upon when the work was created. If the work was created before 1978, which is under the 1909 Copyright Act, it is much easier to claim that something is a work made for hire. That's a doctrine that was never codified in the 1909 Act. It arose by common law, by courts that ended up holding that if a work was created at the instance and expense of the hiring party was presumed, absent some other agreement, to own that work from the outset. And so if you have a situation where somebody hired an artist to create a painting and paid for that and had the right and ability to control and supervise the artist, that would generally be a work for hire. And interestingly, it was often found to be a work for hire under those 1909 Act cases, even if that right of supervision and control was never exercised, even if the artist was working at home using his or her own tools and materials. The courts were pretty liberal in finding works for hire, and so that's why you see in a lot of these cases involving older works, Superman and Captain America cases come to mind, works for hire, even where the creative force was the original authors.
Right. And obviously the standard is much more stringent now under the 1976 Act. It's much more, without getting into all of the details, typical of an employment relationship and usually requiring a contract that expressly states that the works are works made for hire.
Yeah, it's two situations. You have a contract, but that needs to be a signed contract. It needs to be a certain category of work, or alternatively, a true employment situation, a situation where the worker is creating the work within the course and scope of his or her employment. So it's an easy situation if you have a studio that employs all sorts of people to work on a movie. All of their contributions to that film will be deemed to work for hire. It's more complicated when you have independent contractors, when you have people who are doing certain things that are separate from their regular jobs. There are all sorts of issues that arise in determining whether something's a work made for hire. But this is something that we look at in termination situations, because if you can characterize that original creation as made on a for hire basis, that's going to allow you to prevent the grant from being terminated.
And I think the next category is really the category where there might be the biggest trap for the unwary, especially if you're a transactional lawyer who's negotiating agreement on behalf of an author or an artist, and that's the question of whether there's been a superseding grant, or, as the case is sometimes referred to it, revocation and regrant. And that's probably one of the areas where the law is still relatively uncertain, and there are a lot of different factors that enter into that. I'm sure you have a lot of thoughts on that, Aaron.
Yeah, and just to kind of set up the stage for this, let's imagine that you have a situation where prior to 1978, an author assigns his rights in a novel. If nothing else happens, that assignment will be terminable 56 years after the copyright was secured. Okay, that's under 304C. Now, if that assignment is torn up and replaced by a new assignment that's entered into after 1978, okay, then the operative grant, we say, is not the original assignment, but rather the post-1978 assignment. So if there was a termination notice under 304C for that pre-1978 assignment, it would be invalid because there's nothing to terminate. There's no pre-1978 agreement to terminate. Any termination would have to be under the post-1978 statute, which is 203A. Now, just to make things even more complicated, under that post-78 statute 203A, you can only terminate assignments that were made by authors. You can't terminate assignments that were made by heirs. So if you want to talk about the real potential trap here, if the pre-1978 assignment is revoked and replaced by a post-1978 assignment that's entered into by an author's heirs, that assignment will never be subject to statutory termination. And so notwithstanding that if they had left everything alone, there would have been this termination right, there will not be termination. Now, obviously, you can have a situation where both parties go in knowing full well that this is what they're doing, they're trying to extract value, there's going to be some compensation paid for that revocation and regrant. But you want to be careful if you're representing either side to make sure that you understand what the effect of tearing up the original assignment is going to be.
Right, and I think just sort of putting a practical sort of demonstrative spin on it, right? Imagine that you're an heir to some successful author who's had a book that's been successful for decades now, and you get a proposal out of the blue basically saying, hey, we've been paying you, let's just take $1 per unit, book is still selling, we're willing to enter into a new agreement with you where we'll pay you $1.25 a unit.
But we're going to rip up the first.
Right. But embedded in the contract, they might not even draw attention to that. Embedded in the contract is effectively you giving up your termination right.
Yeah, although where we see the court struggling with this issue is how specific do you need to be in order for there to be a revocation and regrant? And for the most part, the courts have held that there needs to be expressed in the document an intent to revoke the first grant. If all you're doing is changing the terms, then that could be seen as an amendment to the original agreement, which doesn't actually revoke that first deal. So again, if you're representing the party that's facing its rights being terminated, it's a good idea to try to get a revocation and regrant, but you want to be very careful to make it explicit. Have the agreement specifically say that the first agreement is going to be gone, it's superseded by this new agreement, maybe even that you're doing so for the purpose of cutting off termination rights. Now, at one point it was argued that that is just an agreement to the contrary. It's the same thing that is barred that we talked about earlier. What the courts have held, and one of the key cases in this area is the Winnie the Pooh Milne case, is that something that has the effect of preventing you from terminating your rights is not necessarily an agreement to the contrary. The issue is going to be, is there an agreement to terminate? And if we rip up that pre-1978 deal, then there is no agreement to terminate. We're not taking away your termination rights. We're just saying that any deal that would give rise to a termination doesn't exist. So there is the ability, if you are representing an assignee and you want to be able to retain your rights, to enter into a new deal. This can also be done under post-78 grants. Those have a 35-year period after which they're terminable. What you can do is you can revoke the original grant and you can replace it, which is going to start a new 35-year clock. So it allows you as the assignee to buy more time. And that's something that's done as part of a renegotiation as well.
And then finally, from the assignee perspective, something that comes up very frequently is just questioning and inquiring as to whether the termination notice is proper in terms of all of the procedures that are mandated by the statute and by the Code of Federal Regulations.
Yeah, so you have issues of specifying what grants are being terminated. Sometimes there are lots of different agreements between the parties, and you need to make sure that you're actually terminating the right one. You need to make sure that you're specifying what works are subject to termination, because the termination only goes as far as it goes. And if let's say there are 5 comic book characters that are transferred in one agreement, and you only terminate 4 of them, that other character is not subject to recapture. There are issues relating to who needs to be notified. There are issues relating to how many years notice need to be given. There are issues relating to termination windows and making sure that the termination is not done too early or too late. And these are things that you're going to want to look, if you're preparing a termination notice, very carefully at the applicable statute, which is 304 C or D for pre-78 copyrighted works, and Section 203A for assignments that were entered into after 1978. Good idea to look at those very carefully, and frankly to consult with a copyright specialist on these, because you can do them wrong in a lot of different ways.
Yeah, and I think that's really the point in terms of taking that point and going back to preparing the termination notice, although I know we're now attacking this from the point of view of the assignee. That's where it is so important to have somebody who is well versed in the termination provisions and has some real practical experience in the issues that come up later on when you serve a termination notice. Preparing a termination notice isn't simple, and it requires some real knowledge and some real diligence to do it properly.
Right, and then of course if you're representing the party who's trying to avoid termination, having somebody who can approach it from the other side and say, okay, this is missing or this is incomplete, will go a long way in trying to challenge that termination. So the last thing we want to talk about today is some of the practical considerations. If you've gotten over all these hurdles, you are convinced that you have valuable rights that can be recaptured, notwithstanding the U.S. foreign distinction, notwithstanding the derivative works issue, notwithstanding the incremental additions to a work that may have been created by the current rights holder. Now you've decided that you want to do this. What are some of the considerations that you're going to want to think about at that point?
Well, I mean, I think one is the time and expense that you're going to put into the process. Really the threshold consideration in almost every termination case, if you're the one who's going to be serving the termination notice, is what's the value of the work? Because even the cost and the time and the diligence that goes into preparing the notice itself can be an expensive and time-consuming process. I mean, isn't that?
Well, sure. Yeah, you got the expense of preparing the notice, and then you have whatever expense may come out of litigation to the extent that the original rights holder wants to challenge it. You were talking earlier about music and compositions being often less. They're not contested as often as some of these literary works. One of the reasons that they may not be contested is that an individual composition may not generate all that much revenue. So you need to decide before you go down this road, what am I actually going to get? Because again, you're going to put aside foreign, you're going to look at U.S., you're going to say, if I terminate this, what's going to be my flow of revenue, and is it worth it?
Right. And I think especially for older compositions, the issue of diligence in preparing a termination notice becomes a big issue in that, not everybody has perfect records and people have to go back and spend some time. Usually the attorney who's preparing the notice also has to spend some time making sure that he is identifying, for example, when copyright was secured in a pre-1978 work, and then also what the operative grant is, and that can be a time-consuming process, especially for older works.
Right. So now, if you though determine after all that yes, it is worth the expense, it is worth the risk of litigation, you next need to think about, okay, what am I going to do once I actually get this back? And the time to think about that is not after you've already served the notice, it's before you serve the notice, because if you know, for example, that by virtue of the blocking rights situation that we talked about earlier, that no other party is really going to be interested in this recaptured work, and that the only leverage you really have is to prevent the current assignee from not being able to exploit it. If you know that going in, that's going to affect your strategy on when you serve the termination notice, for example. The closer to the deadline that you serve it, you can serve it at least 10 years before the window opens. You can serve it up to 10 years before the window opens, but you have to do it at least 2 years. If you want to maximize your leverage and you know that the studio is very into a particular franchise and is doing remakes on that, you may have more leverage if you wait until closer to the time that window opens.
And that goes back to the point that we were discussing before. Even if you don't end up in litigation over a copyright termination, there are going to be at least two stages. There's going to be the stage of doing the diligence, preparing the termination notice, but ultimately what that is going to trigger is some negotiation of some sort. And you're going to also want an attorney who, whether it's the person who's handling the termination or somebody else, who's experienced in negotiating those type of agreements and effectively will be able to get you the better deal that you are looking for in that negotiation, whether it's with the original grantee or with somebody else.
Right. So in terms of some of the other considerations that you're going to think about as you decide what your strategy is, how important are foreign rights? Because with some works, foreign rights are very important. With others, each territory is somewhat self-contained, and while it might be nice to be able to stage a musical, for example, in China, it's not essential to be able to do it in the United States. The reason that's important, of course, is because if you are successful in terminating, you do only have the rights back in the United States. So that's important to consider. If at the end of the day you determine that there's going to be synergy for one entity to have both U.S. and foreign, then it makes more sense to reach a deal with the current rights holder as opposed to splintering off the rights and having one company exploit U.S. and one company exploit foreign.
Yeah, and I think that the point, the broader point that goes to that same point is, what we're all experiencing is that the content market is a much more global market than it was even 10 or 20 years ago. So in a lot of instances, companies there won't be as much of a interest in a property when there's only the ability to make use of the domestic rights, but all the foreign rights are tied up. So once again, that's an important consideration to take into account when you're about to move down the road of a copyright termination.
There's also a practical consideration, and this is especially true when you're dealing with the terminating party being heirs as opposed to the original author. Oftentimes, especially if it's a pre-1978 work, the original author is deceased, may have many children, may have even some deceased children that have their own kids. And there could then be many people that you need to corral if you're trying to exercise these termination rights. And the statute tells us that you need to have a majority of the interests that agree to terminate. So if you have a big family and you can't get agreement, then chances are you're not going to be able to terminate in the first place.
Yeah, and I think some concrete examples of that I've run into. For example, I had an instance where there was a widow who was a second wife and children of the first wife, and there's difficulty just even sort of reaching a consensus as to whether to terminate or not. Even when there are, for example, multiple authors who sign the initial grant, there can be difficulty in just rounding up those people. You can think of a rock band where people don't get along anymore. Those are all instances where just practical considerations can, make it difficult even to get to the point of preparing a termination notice.
And on the flip side, just again going back to if you are challenging a notice, you want to try to do as much research as you can regarding the number of children that a particular author had, whether those children are alive or dead, how many children do they have, because if you can demonstrate that they don't have that majority of the interests, that's another way to be able to shoot down the termination.
Yeah, and I don't want to make too big of a point about this, but it's all children. Whether there's no concept of quote unquote legitimate or illegitimate children under the Copyright Act. It's a majority of all of the children if we're into that class of heirs who needs to terminate. So that's something to keep in mind as well.
Okay, any last thoughts?
I hope this was productive for those of you out there who are listening, and I think the one takeaway is that obviously copyright terminations, and we haven't even really spent time going through the timing aspects, the 35, 40, or 56-year aspects of when termination is effective. Nonetheless, it's a very technical area of the law. There are a lot of considerations to keep in mind, and it's something where don't wade into those waters unless you have some experience, or at least some really substantial experience in copyright law before you start endeavoring there. Thoughts?
I agree. Okay, thanks a lot.